California public policy favors the mediation of litigated estate trust and elder financial abuse disputes. Mediation communications are confidential, part of a legislative effort to promote effective mediation. This confidentiality is a recognition that candor is necessary to a successful mediation. The confidentiality shield for such candor prevents a later challenge to the frank expression of views during a mediation. So it's one thing to have legislative protections of mediation confidentiality, and it's quite another for litigating parties to enter into meaningful mediation. Mediated settlements ultimately reflect the disputing parties' assessment of their own interests, coupled with the decision that continuing litigation seems less attractive than a settlement. In other words, the deal-no deal balance favors the deal. Litigation of beneficiary and inheritance disputes often wind their way into a mediator's boardroom. The parties are usually separated, and a neutral third party, that is a mediator, seeks the common ground that might result in a settlement. The process is rarely instant, and serious negotiations often take place late in the day after the parties have felt the weariness that characterizes a litigation battle. The mediation process itself requires a number of decisions: mediator selection, efforts to understand the negotiating style of opposing parties, as well as the style of the mediator, and the identification of barriers to agreement. That all this is part and parcel of the mediation process. A great mediator will focus on factors that can surmount these barriers. Experience in mediation counts. It's not the only thing that counts, but it definitely counts. It takes experience to recognize the various categories of negotiating styles. There are some very general styles and some that are very peculiar. Whatever style makes up the process, mediators will often remind the parties that mediation allows them to choose their settlement and not have a third party, a judge or a jury, impose a resolution on them. It's important to know that in estate trust and elder financial abuse litigation, that there's likely to be a time that you and the opposing party arrive at the same conclusion. The deal-no deal balance favors a deal. The terms of the deal will be unique to the litigation at hand. So, if you have a trust beneficiary or a disinheritance dispute and you want to talk about it, call us at Hackard Law 916-313-3030. We represent clients in most of California's major urban areas, including Sacramento and the Bay Area, Los Angeles, and San Diego. We take cases where we think that we can make a significant difference and there is a wrongdoer who can be made financially responsible for their wrongdoing. Thank you.